Welcome to the 2024 Cook County Board of Review Attorney Presentation. I'm Kristen Duffy, the General Counsel of the Board of Review. First, I would like to acknowledge the leadership of the Board of Review, Commissioner for the 1st District, George Cardenas, Commissioner for the 2nd District, Samantha Steele, and Commissioner for the 3rd District, Larry Rogers, Jr. Here's today's agenda. We will not go through each slide. Rather, we will highlight changes to the rules, best practices and reminders, and suggestions to make the tax appeal process more efficient for the Board of Review, the taxpayers, and the practitioners. Today we will cover the Board's requirements and procedures for the 2024 tax year appeal session, the Board of Review rules and revisions, mandatory historical summary forms, the 2024 intervenor valuation rules, and the 2024 exemption rules. Clarified rule number 1. Only licensed attorneys and individual taxpayers representing themselves pro se may practice before the board. Individual taxpayers may represent properties titled in their own name pro se or retain an attorney to represent them before the board. All parties other than pro se taxpayers must be represented before the board by an attorney. Other taxpayers, including but not limited to entities such as corporations, LLCs, condominium associations, and the like, must be represented by an attorney. A person who is not an attorney may not represent a taxpayer before the board. Remember that if you have an attorney code, you must file as an attorney regardless of whether or not you are being compensated. Here we have clarified that if an attorney is representing a friend pro bono, you must file with an attorney authorization form. 2024 forms are available on our website. Please note that failure to file with an attorney authorization form will result in a no change 7. The form must be clearly labeled as the attorney authorization form because our system looks for that keyword. Also, failure to follow the board rules or the rules of professional conduct can be grounds to suspend your attorney code temporarily or permanently. The attorney authorization form for 2024 can be found here as well as on our website under the Forms section. For rule number 5, we are adding a link to the complaint form. Rule 12 provides for hearings that will be held at times and dates set by the board. The board will notify the taxpayer or his or her attorney of the time and date of the hearing. Should members of the public wish to observe hearings, there are instructions on our website. If there is a request to observe a hearing, we will provide advance notice to the parties. In Rule 13, we have clarified that late evidence will not be accepted by the clerk's office. Only late evidence provided in response to a request of the board made at a hearing or indicated in the case file, notes, or decision of the board will be accepted and considered on re-review. Changes to Rule 14 clarify and highlight the Board of Review requirements. First, a brief shall include a color photo of the front of the subject property taken within the previous 12 months. That photo should show the condition of the property as of the lien date. Second, parties shall submit a brief as well as a complete historical summary form. The existence of any transfers or appraisals must be disclosed, and if an appellant believes that any value listed on the historical summary form is not indicative of fair market value, that should be addressed in the brief. In 2023, there were 4,209 requests for re-review. Re-review is governed by Rule 26, and just a reminder, re-review is akin to a motion to reconsider in circuit court. Re-review is not the place to raise new legal theories or factual arguments. Re-review is not the time to submit documents required by the board. Submitting new evidence is at the discretion of the board and only upon the showing of good cause or exigent circumstances. Also, you must state specific grounds for the re-review request from the list below. Failure to articulate one of the grounds for review shall result in dismissal. Rule 26 lists specific grounds for re-review requests. Please note the changes to subsection A. Subsection A allows for new evidence only where provided in response to the request of the board at a hearing or indicated in the case file, the notes, decision, or at the discretion of the board where good cause is shown. After much discussion and consideration and in an effort to return to normalcy and get the tax bills back on their regular schedule, the evidence submission period will remain 10 days for 2024. New for 2024, we have added Rule 27 regarding administrative no change. Requests for administrative no change are not reviewed on the merits of the appeal. Rather, the administrative no change preserves the taxpayer's right to appeal at the Circuit Court or the Illinois Property Tax Appeal Board. All requests for administrative no change must include a complaint, a brief in support of that complaint requesting the administrative no change, and an attorney authorization form. Any taxpayer or taxing body seeking intervention must utilize the Intervenor Upload Center. Here's the link to the Upload Center. Please see updates to the Intervenor rules on our website as well. Make sure to clearly label all documents which are uploaded to the Intervenor Upload Center. The next series of slides will highlight the DAPS enhancements and password reset. Here you can see a custom web page that references each appeal via a link that opens the board notes, the board summaries, and the board result letter. And here's the custom website showing the Board of Review decision letter badge. There are many benefits to the data compilation subscription service, including one-click access, electronic spreadsheets, improved labor cost efficiencies, streamlined filing, minimize manual entry errors, and improved client relationships. The subscription allows the ability to bulk file complaints, bulk upload supportive evidence, and a summary of results for the complaints filed. Please note that if you are uncertain whether you'd like a hearing at the time of the bulk filing submission, you can reserve your right to a hearing by placing any other text other than yes or no in the column on the spreadsheet. You can later make a hearing election up to the evidence submission deadline. The deadline to purchase the 2024 subscription service is August 20th, 2024. Just a reminder, if needed, you can reset your password, and you can do so yourself without contacting the chief clerk. Prior to 2022, you were required to contact the chief clerk to reset your password, which was not efficient, especially on the day of the deadline or after hours. Step-by-step instructions for resetting your password can be found on the next series of slides. We'll now talk about best practices for filing, evidence, hearings, and attorney substitutions. Please note that any and all upload issues should be immediately reported to Chief Clerk Manuel via email. Many times, an issue arises and someone receives a No Change 7, and at re-review, the taxpayer will state that they encountered upload issues, resulting in the failure to make their timely submission of documents. However, there's no documentation of that upload issue for the board to consider, and possibly address any tech issues. So please, if this occurs, immediately notify Chief Clerk Manuel via email listed here. Due to health and safety concerns for the Cook County taxpayers, practitioners, and the Cook County Board of Review employees, the Board did not conduct in-person hearings for the 2020 tax year. The Board realized specific efficiencies from the non-in-person proceedings which continued for the 2021 through 2023 tax years. Therefore, non-in-person hearings will continue for the 2024 tax year via telephone for pro se and video conference via Teams for attorneys. See Board of Review Rule 12. Hearing requests substantially impact the Board of Review's resources and scheduling. In 2023, there were 246,774 complaints filed, which encompassed 408,454 PINs. There were 10,390 hearing requests, both attorney and pro se. And in 2023, there were 271 CBD hearing requests. During the hearing, explain and disclose any and all changes in circumstance. Disclose the type, size, and use of the property. Please remember that hearings are not an extension of the evidence submission deadline. You must also disclose any pending assessor recommendations or CFCs, disclose any prior PTAB or SPO decisions within the triennial, disclose any and all information regarding omitted assessments. Please do not request a hearing simply to attempt to negotiate a pending PTAB. An oral hearing is not the time to discover what late evidence to submit at re-review. Overall, please know your property. The Central Business District oral hearings are done en banc by the most senior analysts. This year, keeping with our efforts to be as efficient as possible, the CBD oral hearings were done with dual benches of the most senior analysts. The CBD hearings take 10 to 14 days of preparation for the commercial analysts. Scheduling the CBD hearings takes 3 to 4 days. We anticipate next year's CBD hearings will be similar to this year's. Matters will be taken under advisement with no decisions rendered from the bench. One commercial call of 27 complaints requires a minimum of 2 10-hour days of preparation for the hearing officer. 1 day of hearings requires 2 days of preparation where the hearing officer is also unable to review and adjudicate desk review complaints. The scheduling of hearings for each group requires 4 to 6 days of scheduling, depending on the volume. Please be mindful of the Board of Review resources when deciding which cases to set for hearing. The following appeals are most efficiently and effectively handled by a desk review. Please review this list. It is very important to properly identify each of your documents, especially the attorney authorization form, which must be separated from every other form. If not, you will receive a No Change 7. It is very time-consuming for the Board of Review to redact personal information if a file is responsive to FOIA. Please make every effort to comply with Illinois Supreme Court Rule 138. It is highly recommended that personal identity information should not be included in any documents submitted to the Board of Review. Personal identity information is defined as follows: Social Security and individual taxpayer identification numbers, driver's license numbers, and financial account numbers. The exclusion of real estate taxes as an expense. The Board of Review's approach to income-producing properties is consistent with most assessing bodies for ad valorem tax purposes. In considering the income and expenses of a property, a decision must be made on how to treat the property taxes. When a property is valued for ad valorem tax purposes, taxes should not be considered an expense because any deduction from the gross income directly affects the indicated property value through the income approach. Only typical and reasonable expenses can be used. When valuing a property for ad valorem tax purposes, therefore, property taxes cannot be shown as an operating expense because the actual taxes are not known as of the assessment date. Income and expense data. This is Rule 20, previously Rule 21. It is very important to submit rent rolls maintained in the ordinary course of business, not attorney-prepared summaries. I&Es should be current at the time of the board filing, not at the assessor filing. Fully explain the I&E data. Disclose whether any leases are net or gross. Also, remember that all taxpayer submissions are subject to FOIA. Here you will find the Cook County Assessor's policy on cap rates. You can see here in this hypothetical how the load or no load cap plays out. And here, for that same hypothetical, is the resulting PTAB refund liability if PTAB granted the appraisal value. The unauthorized practice of law and practitioner expectations. Unauthorized practice of law. Practice before the Board of Review is the practice of law. Therefore, non-attorneys or consultants may not practice at the Board of Review. Attorneys should either be solo practitioners or affiliated with a law firm. Only attorneys may argue cases on behalf of others before the Board of Review or submit or present cases on behalf of others to the Board of Review. The Board of Review enlists the assistance of the practicing bar to bring light to any unethical or unauthorized practice of law issues. Please make sure to complete each of the required documents on the attorney substitution checklist. Incomplete documents will not be accepted. These should be emailed to Clerk Emanuel rather than uploaded into the portal. Inaccurate PINs are very time-consuming. Please review all PINs closely and verify that they are accurate. Also, please note that there is a 999 PIN cap on the number of PINs for condo submissions, and you must highlight anything in excess of that 999 PIN cap. If you exceed the cap, you will need to file a second complaint with the additional PINs. The following townships will open for pre-filing: Riverside, River Forest, Norwood Park, Rogers Park, and Evanston. Group 1 will open on July 22nd. Thank you for taking the time to watch this presentation. A copy of the presentation will be made available on our website, and it will be sent to the practitioners as well.